and I'm actually glad you covered it because I think it's something that went under the radar. And I think a lot of people just let it blip was the Crumblies, right?
Oh,
so you
yes.
cover them.
Yeah.
So I didn't
on that last night.
So I you know, and yeah, I don't want to go 2 hours, but I want to get your initial thoughts on it because, you know, when I initially covered this, I was focused on the legal precedent, right? And I think this issue breaks down into two separate issues. One, the specifics of this case and them not liking the Crumblies, and frankly, look at them. I mean, they look like white trash. It's involving a shooting, right?
Yeah.
So I think those facts,
worse than a school shooting, which is
right,
like,
school shooting, right, which is the #1 no thing in America. You know, forget about the inner cities and the shootings that happen there every day that kill more people than any school shooting.
There's white people getting shot.
These are white people getting shot. Yes. And if there's white people getting shot, you know, maybe the odd Asian and Hispanic, you know, we gotta pay attention. Yeah. So let's first remove it from the Crumblies. So let's remove them from the picture. Just in general, like, are you against the principle of parents being charged? Because here's my comment to you, is that, because I'm pretty sure, as with most people are against parents being charged, with lawyers I've spoken to. But here's the thing: don't we charge parents already with negligence if they're, you know, not taking care of their child? They're charged with some sort of neglect, right? So they can be held criminally culpable for their care of the child, for their actions towards their child.
Right.
So, and in fact, even maybe their non-action, if they were to do so, if they fail to do something a reasonable parent would do, that can be criminal, correct? So
if you give me 5 minutes, I can go through a pretty good synopsis of what I spent 2 hours covering yesterday.
Yeah, go knock it out. I want to do it.
Because I walked in with the mindset of, how the heck are they charging these parents? And there was a 3-panel bench, and first they start with there's 2 different attorneys. Each defendant has their own attorney, although I think they're in the same firm. But the first one seemed far more professional, and you know, you can start with a question as to, this should never happen, this should never be allowed, period, end of story. Or you could start from the second prong. Oh, God bless you. You're amazing. Thank you. Yeah, I got my Thursday night pizza there. There you go.
Awesome.
Popping on in. Homemade.
Oh, I am so jealous of the pizza right now.
Yeah.
That's great.
So, courtesy of Lady Logic. So so you could start either on that higher thing, which is, it should never be, but if you're ever going to do it, this is not a case where you should do it. Or you could start with, this doesn't rise to a level, in which case you're almost giving up on the first argument. Well, the first attorney to get up for James Crumbley almost gave away the argument that it should never be, and started with, like, this is not an appropriate place for it. Okay. The second attorney, the one for Jennifer Crumbley, started with, it should never ever be. And
which is important because they have separate attorneys, you know, because they're separate individuals. So that's not good when the defense is going in 2 separate directions.
Yeah, someone wants me to increase my mic gain, so I can boost that a little bit for you.
Here, let me see if I can do it on my end too.
No, I lowered mine because I was always too hot, so I was down like at 37. I think now I'm probably like booming in some people. All right, well, anyway, so that's one. So those were the different tactics that they took, and the bench was coming after them with really tough questions and focusing in on, like, you know, they knew about the gun. The first thing he did is he ran home to get that gun. James ran home to get that gun 15 and see if it was there 15 minutes after, and never bothered telling anyone in the school about it. And you know, this was clearly the most foreseeable thing in the world. Everyone knew about it. And the attorneys are arguing back pretty effectively, you know, saying, like, you know, that he didn't know about the gun. And that when he's like, and even the school counselor, they had the gun in their possession in a bag, not realizing it, didn't bother going through the bag themselves. The school counselor never sent him home. They said, we'd like him to go home, but they had every opportunity to tell him he must go home. And they didn't, and because nobody thought he was a danger to himself. Right. Yes, they thought, if anything, he's a danger to himself. Nobody was considering this a danger to the public and his fellow students. And that's why they basically said, you know what, we think that'll be best for him to stay around kids so that he has a social atmosphere, rather than him going home and potentially blowing his, which is a call.
which is a call on the school's part. And by the way, the school, when it has the child, is acting in loco parentis.
Correct.
So literally,
Actually,
it has the same standing as the parents. That's a very important doctrine.
Correct. And I actually threw that. I mentioned that last night. And the court seemed very pro-state. And to the court, and I say this to the court's credit, even if they end up deciding against what I would decide, in that when the state was up there, they were ripping apart the state and saying we should never allow this and whatever, and trying to distinguish between different cases. And the one case they talked about is a case that they called the head case that wasn't even familiar with. When you hear head case, you don't think you're talking court case, you think you're talking about Ethan Crumbley. But there's a case involving someone I think named Zachariah Head or something like that, who was an adult who assisted a minor, or I mean, I didn't go through the facts of the case, but basically was a third party, not the actual shooter, but helped facilitate the shooting. And the clear distinction that I drew from this, and that I think everyone should draw, is this: you have to ask yourself, instead of looking backwards, this is the healthiest way from my mind. Instead of looking backwards and saying, what could they have done differently? You can always say, what could they have done differently, and kill yourself with regret. Whether you're James and Jennifer Crumbley, even the school counselor could do that and say, wow, if I only sent him home, wow, if I only looked in that bag, so many things, if I only looked at this whole situation differently, perhaps 4 people would be alive who are now dead. And that's a lot of deep shame and regret and guilt that people should carry. And what I urge, if any of them ever see this, which I doubt any of them will, but if the counselor's watching this or the parents are watching this, you cannot give yourself that you should not try to live with that or feel that it's your fault, because all the time, every day, we make 1,000 decisions, and we're trying to do our best based on the information in front of us. And to sort of say, wow, if only I did this, is a terrible way to live. And I don't think it's a fair standard to hold a parent to, or a school counselor. I don't think the school should be held liable here either. They were doing their best based on what their training taught them, that this is the most likely way to benefit everyone involved, including Ethan and his fellow students. So that's really what they were looking to do. The difference here from that head case that the court mentioned is that person had knowledge at the time that they the time everything was happening, that this person has a plan to do harm. And when you have knowledge that a person has a plan to do harm, and I'm not sure if that's the head case or a different case, but when you have knowledge, so I don't want anyone to mistakenly say, no, that's not the head case is about. But if here's the dividing line is, if at the moment something is happening, you have knowledge that someone has a plan to do harm, then you are a facilitator of that plan. Doesn't matter if you're a parent, you're a guardian, you're a next door neighbor, whatever it is. If you know someone's plan and then you enable it, you make it easier for them to enact that plan, you are now a facilitator to that plan. If someone wants to be charged criminally in that setting, fine. I understand that. That makes sense. You're basically endangering the welfare of the public. But if you don't have knowledge of that plan, to start saying that there's a duty, first you have to figure out who is the duty from, who is the duty to. Parents.
Yeah. So who's the duty? Where's the duty from, and where does it to?
You're
saying you have a duty to everybody to protect them from your child.
Why? Why would you have such a duty? You have a duty to your child, so they have a duty to take care of Ethan. And the way they were trying to convert this when they were attacking the defense counsel was they were basically saying, well, he has a duty to. They have a duty to make sure he didn't commit suicide. Why didn't they check the bag to make sure he didn't kill himself with the bag? And they had a duty to him. Okay, let's say that was a duty.
Let's say it is a duty. Let's say it is a duty to prevent him from committing suicide, which, by the way, would be horrible as a precedent. Think about that. Think about charging. Think about, you have a kid who, tragically, for whatever reason, commits suicide. And then the one is the state is going to charge every single kid, the parents of every single kid.
In theory,
every single kid.
That's what Michigan wants.
Essentially. You got to apply it equally. If we're going to do it, it's got to be equal, right? If we're going to hold parents responsible, it's got to be equal. So if we're going to say, okay, it's suicide now, right? Or anything involving a gun. Okay, every suicide death that the kid shoots himself, right? We're going to put the parents on the stand. Every single one. Every single one? No, we're not.
And if Ethan Crumbley, instead of turning that gun on his fellow students, had turned that gun on himself, nobody would have thought to charge the parents. Even though they had a duty to protect him. So if they have a duty to protect him and you wouldn't charge him in that situation, why would you then convert that to say, well, that duty to him, and since they were negligent in that duty, and the result was damage to these, harm or death of these other 4 people. That's a ridiculous way where you're taking a duty that they owe to one person, converting it to someone else, and making it larger than you would have when it wouldn't apply to the first person. To me, this should be a civil suit. They should, the families of the people who were murdered, they want to go after James and Jennifer Crumbley for damages, whatever, and they can establish a duty and breach of duty, which is going to be hard even in a civil suit. If they can do that and they successfully and they get there, that's fine. That's up to the courts to decide and how the laws are written. But with criminally, this is a landmark case. This has never happened. And one of the things that the bench actually asked the state was, is there a single state in this country which has ever charged a parent for the intervening act, meaning a third party's act of a child committing a crime? Has that ever happened anywhere in the country? And the state was like, well, there was one case in Kentucky, but there was a change in politics. They originally brought charges and the charges were dropped. So no, this never actually has gone to trial ever before anywhere. And if it happens in Michigan, I guarantee you, Michigan has been vying to become the new capital of woke.